Welcome everyone to SQE1 window, and here we go in our chapter 4 planning consideration. So now if you thought taxation was complicated, wait until you dive into the world of planning. It's also one of the challenging areas. Look, property is expensive and learning about property is more expensive. So at that point it needs more attention, more hard work at that point. So I hope we will help you make it easy to understand. So right, let's set the foundation. Planning control in England and Wales is primarily governed by the Town and Country Planning Act 1990. The TCPA. This is the framework that regulates what you can and cannot do with land and buildings. Why do solicitors need to understand planning law? For crucial reasons. First, unauthorized development can lead to enforcement action. The local authority has power to enforce the owner to undo the work or face penalties. Second, property value is affected. A property with planning breaches is worth significantly less than one with all proper permissions in place. Third, lenders may refuse finance. If there are planning issues, mortgage companies, banks often won't lend against the property until those issues are resolved. Fourth, the buyer assumes liability for past breaches. When you buy a property, you inherit any planning problem and all, with the property, even if you did not create them. So at that point, so we got real world scenario. A buyer acquires a property with an unauthorized loft conversion that previous owner did without permission. The buyer may face enforcement action from the local authority, or at minimum they shall need to apply for retrospective permission. This is exactly why pre-purchase due diligence on planning matters is very, very critical for you as solicitors. So what is development? So we need to understand the development requires planning permission. So what is development under section 55 of the TCPA? Development means two things. Number one, building, engineering, mining, or other operations in or on, over or under land. Basically physical work, any sort of physical work on the land. Second, any material changes in use of land or building. So changing what you use the property for is once again development. So if what you are looking, or if what you are doing falls within either of these definitions, it's development. And generally speaking, you need planning permission. Here is a simple example. Mr. Johns wants to build a 2-story rear extension on his house. That's clearly a building operation. He is constructing something new, so it counts as development and requires planning permission unless it falls within permitted development rights, which we shall discuss in this session. The key is recognizing what is and is not development, because if you get this wrong, you could proceed without permission, and of course that will cost you and your client, and it may cost you in SQE as well. So what is building operations? Let's try to understand into building operations, because this is where most planning issues arise in residential conveyancing. Building operations include demolition, rebuilding, structural alteration, and addition to building. The list is pretty broad, all of it. Example that requires permission unless exempt or permitted development include house extension, constructing a garage, and even garden sheds if you are over a certain size at that point. But here is what is important. Not everything is development. For example, internal repairs, maintenance and painting kind of thing, those are exempt. So whatever you do inside at that point may be exempt. They don't count as development at all and don't need permission. Like for example, you are just changing things inside. You don't need planning permission. Or redesigning your kitchen from inside, redesigning your bathroom does not need any planning permission. That's not development. So think about it logically. If you repaint your living room or replace a broken floorboard, that's not development. It's just maintaining your property. The external appearance has not changed. The structure has not changed. and the use has not changed at that point. But the moment you start altering the structure or external appearance, knocking down walls, adding an extension, building a new garage, you are into development territory and you need to be careful. Back to Mr. Jones and his rear extension, that's structural alteration and addition. It's definitely building operation, so it's definitely development. The question then becomes, does he need express planning permission or does it fall within permitted development rights? So let's see about material change of use. So this is when you change how you use land or building in a way that's substantial for a planning perspective. Example that requires permission: converting a residential property to commercial office. Changing a shop into restaurant, that's a different use class with different impact on the area. Converting a single dwelling house into house in multiple occupation, that we call it HMO, where multiple unrelated people rent separate rooms. So at that point, that's kind of development. So what does not require permission? Running an incidental home office where you are just working from home occasionally. For example, this is Christmas, so we are sitting at home and we see client in one go. Or changing the type of retail within the same use class, like changing from selling clothes to selling books. Both are retail shops. You don't need any permission. The key word here is material. The change has to be substantial enough to matter from a planning perspective. If the impact on the neighborhood is different, is the intensity of use is different, these are the questions planning authorities ask. So Mr. Smith decides to run a hairdressing salon from her home, for example. Clients are visiting regularly. They have there is increase in traffic, parking, noise. The material change of use from residential to commercial, she needs planning permission. Compare that to someone who works from home on their laptop occasionally. That's incidental and residential use, so you don't need, common sense, you don't need any planning permission for this. Exempt operations. So let's clarify what actually exempt from being development at all, because this is important. Exempt operation include internal works that does not affect external appearance. You can configure your interior layout, knock down internal non-structural walls, replaster, as long as outside looks remain same. It's not development. Use within the same same category. So if you build a summer house in your garden and use it as a home gym or occasional guest room, that's incidental to residential use. It's within your use the land around your house, and it's just supporting your residential use. At that point, it's all right. You place a big box for your garden tools and all. It does not need any planning permission. Agriculture and forestry operations on agricultural land, farmers have specific exemptions at that point. Statutory undertakers work, for example, utility companies doing their infrastructure work, is exempt. For example, the Browns built a summer house in their garden to use as a home gym. That's incidental use within the use of dwelling. It's exempt, not development at all, and does not need a planning permission. For example, I build a pergola or I build a shed outside to use it as my gym outside. I don't need any planning permission. So what are permitted development? Something that looks like development, but that's permitted. So which is absolutely crucial. This is kind of thing you need to understand. So permitted development rights are granted automatically by General Permitted Development Order 2015. These are developments that the law says you can do without needing to apply for express planning permission. The permission is automatically granted by the GPDO itself. Common examples include rear extension within specific limits, outbuilding like sheds and garages within size limit, minor work like fences and gates within height restriction, and changes within the same use class at that point. But this is important. There are significant limitations on it. So you cannot have multi-story, 7-story kind of thing and you say this is also residential and we will live in it. No, there are certain restrictions on it. So first, permitted development is calculated from the original dwelling house. If the previous owner already used up some of the PD allowance, you can't start fresh. It's cumulative at that point. So personal development right can be removed in listed buildings, conversion areas, and by something called an Article 4 direction, which we shall discuss next. Third, there are strict strict size, height, distance limits and all. Exceed those limits and even a centimeter, you need express planning permission. Example, Tom wants to build a single story rear extension that's 3.5 meter deep. The PD, personal development limit of the detached house, is 4 meter, so that's fine, he's permitted. But Tom extension was 4.5 meters deep. Here it is exceeding limits, so needs planning permission. In similar way, Tom builds a garden shed that is 2.8 meters high and meets all other PD criteria. That's fine. It's within the limit, but if it were 3.5 meters high, exceeds the limit and needs planning permission. Very simple. And this one is very important. Don't forget it, Article 4 direction. And these are mechanisms for local authorities to remove permitted development rights in sensitive areas. The purpose is to protect areas where even small changes could harm the character. Think conversion areas, areas of outstanding natural beauty, streets of historic and architectural importance. The effect is that development that would normally be permitted development now requires express permission. Things go very strict. A classic example, a local authority issues Article 4 direction covering a Victorian terrace street because they want to preserve the uniformity of the original windows and doors at that point. Now, even though replacing windows would normally be permitted development, residents on the streets cannot replace their windows without getting express planning permission. The Article 4 direction has removed the automatic right. So for solicitors, this matters, because you need to check whether an Article 4 direction applies to the property. If it does, work that looks like permitted development might actually be unauthorized, and you need to be mindful of the fact. So, lawful development certificates, let's talk about it, because these are really useful for resolving planning uncertainties. So we got like CLOPUD, Certificate of Lawfulness of Proposed Use or Development. This confirms that a proposed development does not require planning permission. You apply before doing the work, and if granted, it gives you certainty that you can proceed without needing express permission. CLEUD, Certificate of Lawfulness of Existing Use or Development. This confirms that an existing use or an existing breach is lawful. This is particularly useful for older breaches that have become immune from enforcement. It is how this works in practice. Mr. Brown converted his garage into a self-contained flat 15 years ago without planning permission. That was a breach, but the time limit for enforcement has passed. It's now immune. He applies for CLEUD. The local authority confirms that yes, this conversion has been in place for over 10 years. The enforcement time has expired, so it's now lawful. Result, Mr. Brown sells. He can provide CLEUD to the buyer and their lenders, giving them certainty that this conversion is lawful, no enforcement risk, property value is protected. So these certificates are extremely important for properties and development. Planning permission applies. When you do need express planning permission, there are two types of application. Outline permission. This is in principle approval. The local authority agrees to the basic concept, but details like design, landscaping, and access called reserved matters, and they are approved later. This is common for larger development where the developer wants certainty on the principle before investing in detailed design. Full permission, this is detailed permission. You submit full plans, elevations, materials, everything. Once agreed, once granted, you can start immediately. This is what most householders like use for extensions and alterations. Planning permission usually come with conditions. These might specify materials you must use, landscaping requirement, highway improvement, restriction on use, time limit to start the development. Conditions are binding. If you breach a condition, you are in breach of planning permission, which can lead to enforcement action. So there are critical time limits. You must start development within 3 years of permission being granted. On the permission lapse, or the permission lapse within 3 years. Starting means beginning the physical work on site, not just ordering materials. So example is a developer gets outline permission to build 10 houses. Before they can start building, they must get approval of reserved matters, detailed design, materials, landscaping. Only then they proceed with construction and all. So the next thing is building regulation. That's another thing apart from planning permission. So building regulation are separate from planning permission. You might need one, both or neither, depending on what you are doing. Planning permission controls what you can build and where. Building regulation control how you build it. Structural integrity, fire safety, insulation, drainage, ventilation. They ensure building are safe and energy efficient. There are two methods of complying. Building notice, a smaller project, you give notice to building control and they inspect as the work progresses. Full plans application, for most projects you submit detailed plan to building control for approval before starting. Once work is complete, building control issues a completion certificate confirming the work complies with building regulation. So here is where FENSA comes in. FENSA certificate, are proof of compliance for replacement windows and doors. There are registered installers. For example, a seller has new window installed by FENSA registered company and has the certificate. Perfect. The buyer and lender are satisfied the building regulation have been complied with. But if the seller used one non-registered installer and has no building regulation approval or FENSA certificate, that's a problem. The buyer's lender may refuse to lend until the position is regularized or indemnity insurance is obtained. Very tricky, but it is safe. Enforcement of planning. What happens when someone develops without permission or breaches a condition? Local authorities have significant enforcement powers. They can serve planning contravention notice requiring information about the alleged breach. They can serve breach of condition notice if you have breached a planning condition. They can serve an enforcement notice requiring you to remedy the breach either by undoing the work or applying for retrospective permission. For serious cases, they can serve a stop notice requiring immediate cessation of work and seek a court injunction and even exercise right of entry to your property. The crucial bit, there are time limits, and that time limits are very important for your SQE in England. From April 2024 onward, there is a single 10-year time limit for all planning breaches. Before 2024 in England and still currently in Wales, the rules are 4 years of building operation and changes to residential dwelling use and 10 years for breaches of planning control. So once these time limits expire, the breach becomes immune from enforcement. It's lawful. For example, Mr. Khan built a 2-story extension without planning permission. The local authority discovers it and serves an enforcement notice requiring her or him, it's Mr. Khan, him to remove it. So his options: appeal against the notice, apply for retrospective planning permission. If granted, problem solved, or comply with the notice by removing the extension. But if Mr. Khan had built this extension 11 years ago and it's only just been discovered, in Wales it's now immune beyond the 10-year limit time. No enforcement action possible at that point. So, enforcement of building regulation. Building enforcement is different from planning enforcement and has strict time limits. Local authorities have 3 enforcement options. Number 1, prosecution. They can prosecute the person who carried out the work, but this must be within 6 months of discovering the breach and within 2 years of the work being completed these are short time limit. Number 2, enforcement notice. They can serve an enforcement notice requiring the work to be corrected, and this must be within 12 months of the work being completed. Again, a short time limit. Injunction. They can seek court injunction requiring compliance. There is no time limit for this. They can apply for an injunction even decades after the work was done. Here is why this matters in convincing. Example, a house was built in 2010 with a building regulation breaches. It's now 2025. The breach is discovered. Can local authority prosecute? No. That more than 2 years since completion. Can they serve an enforcement notice? No. More than 12 months since completion. Can they apply for injunction? Yes. No time limit. So the risk never fully disappears. This is why buyers and lenders are so concerned about missing building regulation approvals. Even old breaches can potentially be enforced through like injunctions and all. So that's what is very, very important for a solicitor to understand. So practical advice for buyers. So how do solicitor protect buyers from planning and building regulation risk? You need a comprehensive check for this one, like what to check. That's the first thing. Planning permission for any extension or alterations, building regulation approval for any structural work, FENSA certificate for replacement of windows and doors, completion certificate confirming work was inspected and passed. Option, if documentation is missing, you can apply for regularization certificate. This is retrospective building regulation approval, where building control inspects the work, how, and at that point, like how it was done, and now and it issues certificate if it complies with everything. The next thing is you can obtain indemnity insurance, an insurance policy that protects against financial consequences if enforcement action is taken. So buyer and lender consideration, that's what we need to look at. Both need to assess the risk. How old is the work? Is it visible from the street? Has it been in place long enough to be immune from enforcement? What does the insurance cost? And what are the policy limits and exclusions? Example, a property has an unauthorized loft conversion. There is no planning permission or building regulation approval. The work was done 6 years ago. The solicitor advice, request a CLEUD for planning, that certificate. If the work is over 4-year-old in Wales or was done before April 2024 in England and it's a change to dwelling, it's immune at that point. For building regulations, obtain indemnity insurance because enforcement via injunction remains theoretically possible. Only proceed to completion once the position is resolved to the buyers and lenders' satisfaction. So the next thing is checklists for solicitors. Stage 1, pre-exchange, review the property information form carefully, check planning history with the local authority, examine all certificates, planning permissions, building regulations approval, FENSA certificate, calculate enforcement time limit to see if any breaches are immune. So raise inquiries with seller about any missing documentation or unclear planning history. Consider whether immunity insurance is indemnity insurance is needed and obtainable. Pre-completion, confirm all identified issues has been resolved, insured certificate has been obtained, and indemnity insurance is in place. Report to the client and the lender, ensuring they understand the position and are satisfied before you exchange and complete. This systematic approach ensures buyers and lenders protection, reduces future liability for negligence, and prevents nasty surprises after completion. So planning due diligence is not optional, it is essential. So let's go to our favorite slide, SQE1 tips and pitfalls. Tip number 1 is development versus exempt versus permitted. You need to understand all of it, like, time limits, size and everything. Number 2, of course, time limits. The time limits are crucial for enforcement immunity. Remember the difference. England post April 2024, it's 10 years for everything. England pre 2024 and Wales currently it's 4 years for building operations and exchange to dwelling use, 10 years for all other breaches. Get these wrong and of course you miss your marks in your exam. Building regulation, these are separate from planning permission. Always verify that both have been dealt with where necessary it is. Check for completion certificate and FENSA certificate. Don't assume that planning permission means building regulation have been complied with. They are completely different. Use example. So practice with common scenarios: rear extension, loft conversion, outbuilding, changes of use. Know the practical permitted developments: 4 meter for detached house, like at that point 3 meter for other houses for single story rear extension, outbuilding up to 2.5 meter high if within 2 meter of a boundary. Common pitfall: don't confuse permitted development with exemptions. Permitted development is still development, but it is exempted at that point. Don't forget about Article 4 direction. Of course, even developments like, permitted kind of things become like, go under planning permissions. So certificates which can be taken to just prove that planning permission, it is immune from planning permission or it is lawful now. At that point, read the facts carefully, like once you are in exam. And of course, like once you read it carefully, it will disclose. I think like understanding a question is half of the answer. And I wish you all the best with full answer. And if you like this session, I request you to subscribe it, share it with your friends. All the best. Ta-ra.